Hi everyone, how are you? This is our seventh episode in the Katie Joy series, which is now going to be renamed with an LED crystal ball. Do you like it? I just love it. I found it at the Dollar Tree. It's in their $5 section, so not a dollar at all. Um, I'm sitting here. I've got my blackberry tea from the Quick Trip in the cup, so I don't have my usual hot tea. Um, the thing is that while I am going to read every single thing line by line for this case and every other case that Katie Joy has been in, there are so many things right now on the Reddit boards and otherwise that are pretty much taking on a life of their own. Wasn't this cool? The LED going on the wall. I'll look at that too. I'll let you guys see that too. Mainly because of all of the lies that Katie Joy is. She creates lies. She is either very, very naive or just absolutely vicious. The things she says and does are just absolutely unfair, irresponsible, and downright lies. So her lies take on a life of their own in many, many, many things. So I want to set a few things straight to the best of my ability and then show you some of the things before I get back into reading straight line by line where we are. As I say, I'm going to go through every single thing so that you'll know. Because I think that it's time that that is done. Because her lies have gone on for too long. And she intimidates people with those lies, and they think that she's not doing anything wrong, and that the judge says this and that about the other side and this and that. And nothing could be further from the truth, really. One of the things that bothered me was a couple of weeks ago, she had dug up a medical bill from one of Cody and I think it was actually one of Robin's children, from Sister Wives. She dug up a medical bill in collections. And I don't know what kind of tea she thought that was, but that's very unfair coming from a person who has a medically fragile child, which only gives more credence to the fact that she has the state covering her medical bills for her son. Now, she went pretty hard at somebody who said that before. But in Minnesota, we have programs, as do most states, for medically fragile children. There are programs so the parents don't see the bills per se, especially if she's going through she's going through Gillette. I know that she's went there. Gillette's really good about not sending anything to collections, etc., etc. Now, from what I understood, where she put that medical bill that was in collections for, I think people said that it was one of Robin's sons, and Cody married her so that she'd have insurance, something like that. So they were wondering why she didn't have insurance and why that bill went through for her son. I guess that her son had a very terrible ATV accident. So I know what's going on with that. It's in the Las Vegas area, and the Las Vegas area hospitals are for profit. They are owned by, most of them are owned by Catholic something West. I can't remember what it is, but it is absolutely for profit. So what happens when you have insurance is you have insurance for basically anything that you would need. You don't think that you would ever need anything more than what your basic insurance is. And I'm assuming that they had insurance. But when you have a catastrophic illness or injury, your bills will very quickly exceed the $1 million cap that most people have for the year. And that's likely what happened from his accident. Now, what happens when you don't have the state protecting you, and you're a regular person who has to deal with bills and whatnot and pay for insurance? Your insurance pays a portion, and then you're responsible for the other part. And it takes a long time for all of the bills to go through. You can see multiple different providers. There can be different, you probably had to have x-rays and other radiology, and then there's radiologists involved. There's all of these different people. And while you're waiting for your insurance to pay them and figure out what your patient portion is, those for-profit companies, medical companies, will send you to collections. Medical illness is one of the main causes for people to have to claim bankruptcy. I don't understand why she thinks that that is something that she's dropping the T on, and that everybody should be like, oh, wow, she found that one of Cody's stepchildren was hurt and one of the bills went to collections. Why is that something that she should bestow getting $400,000 a year for? This is the kind of crap reporting she does. Okay? I can only imagine what she's going to show on me. I mean, it's going to be that, because when I was in Vegas and I had my catastrophic illness, I found out all of these things. I wouldn't know otherwise. But for her to be in a position where her bills are most likely covered, to throw shade, to act like it's tea on another mother, what the, honestly, it's ridiculous. I don't know why that's something that she doesn't get in trouble for. If anybody says anything about her child or medical bills or anything, she goes for, saying that's harassment, etc., etc. But she can do that. It's really, really bad. I'm disgusted, quite frankly. Now, one of the things in Minnesota that people with medically fragile children can get is something called a CADI waiver. CADIWAIVER. And it's a $10,000 budget to have your vehicle modified for your child, things that insurance do not cover. I never have received it for my child with cerebral palsy. I only recently found out about it and found that I could have gotten it all these years from one of my doctors, who they get it for the child that they adopted with cerebral palsy. So I am confident that she gets that along with other things, because when she was talking about her vehicle and how she went to the sports, there was just language in it that made me think that she was doing that for a purpose, and maybe it was for that purpose to use that money for that. I don't know. But for Minnesota to have that, it protects people from having things in collections. And like I say, I don't see how that's any of her business. It just goes over and over, just showing how shallow and snide she is. It's just, like I was talking about, subscribers are the ones with all of the power, because of the amount of people that subscribe to Katie Joy, she makes 400,000 a year. She's worth 1.2 million. The hands are in the subscribers. The power is in the hands of the subscribers. When you subscribe, you really need to know that you are contributing to something. And so if you subscribe to Hate Watch, you're doing the opposite. If you hate watch, just don't subscribe, and watch clip channels that get everything, in case you miss something, which, I don't think that you will, but, and just think about that power that you have as a subscriber. And, thank you so much to all of my subscribers. You guys, like I said, when you guys are new, I hope that you can see coming in that I have an amazing, amazing community, as I've said. And it's so great because I'll be going throughout my day and I'll be busy as heck doing this and that. And something will pop up on my phone that there's a comment on my channel. And it'll be something like amazingly nice that'll just pop through. And I'm like, I wish I had time to answer, but I don't. But it's just getting that constant encouragement and positive interaction and knowing that you guys are listening. And it's just amazing. So I'm grateful for the power that you have as subscribers in making my channel work and working together. As I've said, I think it's kind of unheard of to go for as long as I have without having mods and needing mods when I go live. You guys are all just so great, so cool. Now, somebody asked me, this is the other thing. When she reported that Robert Shin has a $1.2 million house, oh my God, how can he afford that? Well, she's such a dumb bitch because where Robert Shin lives, a $1.2 million house is nothing. In her neighborhood, she lives in the original part where the homes were, they probably went up because on her part, it was the older part, 10 or 15-year-old houses or whatever. I don't know. But then down the block from her where I was going to build, they built the newer homes, and those were going for, 4 to 5. I think ours was on the edge of, I think ours was like 380 that we were looking at. So her home value would have went up due to the new buildings in the area, but her home itself is very, very for the area, living in Minnesota, for a family, she has one child, so for a family having one child, she's probably sitting in a house that's, 300,000 to 400,000. That's very, very average. In California, it's not. In California, to buy a home for a family, it's going to be in the $1 million range easily. And it's not saying that his house is super nice for $1 million. Here in Minnesota, you could have a very, very nice home for $1 million, $1.2 million. But in California, you wouldn't. When we lived in Southern California in Irvine, our home was $1 million home. It had, let's see, it was a 5-bedroom, 5-bath, and it was right at the $1 million mark, but that's because everything is relative. My husband was in the I can't remember the word right now. He was a lender. He was doing mortgage loans, and so he was in the subprime mortgage lending business. So right before the housing market totally fell out. That all of the whole industry crashed. So the company where my husband was working at went under. It was a great company. He was doing really well at it. His commissions alone were 25,000, so that wasn't even counting his wages, and that was normal. That was a normal income for living in that area of California, and husband having a corporate job, and me um, being a stay-at-home mom still because I was sick, but with 3 kids, and so we were living in a very average neighborhood right outside of Riverside, in Corona, and my husband worked in Irving. So if that home were out here, it would be a home that would be probably 500,000, but in that area of California, it's 1 million. So if her home were in California, it would be probably an $800,000 or $900,000 house. Everything is relative, and I don't think she gets that. I think that she has been very sheltered and hasn't traveled much, doesn't understand the world, doesn't understand how people are. I think that she really sits inside in her own little world and thinks that she's something, but literally, she can go anywhere. Nobody knows who she is. YouTube is something that you go and you seek out. It's not like it's out there on the television. And she's not, I don't know how she is listed as a nationally recognized journalist. I don't know where that term came out, but I don't think anything could be further from the truth. I think when it gets broken down into what she really is, it's gonna be an eye-opener. So the other thing that somebody asked me about is, how is it that she can have a cat out there that goes indoors and outdoors and is not vaccinated? Is she in that remote of an area? Because people were concerned about a cat being unvaccinated coming in and outdoors around her child who is medically compromised. I would be shocked if she's letting a cat go inside and outside. When I adopted my cats, I had to sign a contract that said that I would never ever let my cats go outside in Minnesota, that they are they have their tag in them, so they're ID chipped. If they were ever found outside, that they would be surrendered back to the shelter, and I would never be able to get them back because of the birds of prey out here, the rural nature of Minnesota, the wildlife out here. You cannot have an indoor-outdoor cat. It does not work. Some people have farm cats and they don't live very long. It's very sad. If she's having a cat go inside and outside where she's living, she's an idiot. It would be very dangerous. And to have a cat not up to date on their shots and whatnot, that's asinine. The diseases that are out there, and I cannot believe she would be that stupid. But at this point, nothing surprises me. Somebody else asked, let's see. I'm seeing a lot of questions and commentaries on Reddit and whatnot, again, because people are concerned because she's deleting so much. This is what I want to show you guys. I don't think that anybody realizes how good Robert Shin's attorneys are. They have, I want to show you just for a second an example of what they have. So what they've done with her posts is they have put these things through like this. So they have it in Exhibit D, Exhibit E, and we'll go through all of these. I have all of them, but let's see, Exhibit C. So as you can see, they have all of this. Okay, so if she's going through and deleting, she is, of course, in violation of what she's supposed to be doing. She is a sociopath. She knows right from wrong, but she chooses to do wrong. So she knows that she shouldn't be, but she is and does. She wants everybody else to follow the rules, but she won't. So the other side is pretty astute. I just want you guys to know this. And, these are things that were filed back in 2022. So they have everything memorialized, and they've got it really down to a science, the way that I've seen them have things. So she's deleting. If people see things that they're concerned about that she posts, I don't think that it would be too difficult to find Amber Stavig's email address, and they can certainly send things that they've seen that she may want to see to her email. I don't think that it would be very difficult at all. I mean, isn't it right there? Like ASTAVIG@DudleyandSmith.com. I think it'd be just that easy to just send an email if you see her doing something like that. Before we get back to everything, again, I just kind of wanted to show a couple of things that people are really concerned about, and how I can see that they've happened. Now, this is dated July 11th, 2023, and this is where we have the substitution of counsel, and it's where it says that please take notice that counsel for plaintiffs has moved law firms from Dudley and Smith, PA, to Stavig Law P. LLC. All contact information is provided below. So that's an older one where I just looked at. Okay, so if we go over here, then we have Stavig Law P. LLC, which Amber at staviglaw.com. So Amber at STAVIGLAW.com, attorneys for plaintiff. So that's where people were kind of confused as to where it went from Dudley and Smith. And I see it here just coincidentally as I'm talking. It makes sense. So that's where, because some people were like, well, wait a minute, how did Amber come in? And were other people with her, etc., etc. So, like I say, she's like Xena warrior princess. She's very, very cool. Now, the other thing that I wanted to just touch on is definitely the protective order. Now, the reason why, this is my opinion, the reason why there's a protective order is because Amber Stavig, counsel for Robert Shin, has a good idea as to what's going on. As I've said, she's very young, very much into understanding the internet and understanding people like a Katie Joy, even though she's one of a kind in her trolling and rolling and everything else that she does. But I think it became very clear to most anybody who was watching this from a distance or close that basically Katie Joy goes as far as she can because all she cares about is finding out more and more information. At the end, she knows she'll have to sign a check. She doesn't care. She wants to find out about people. She wants to find out the inside details. She goes and pushes and pushes and pushes because she wants to be the one with the scoop. She wants to be the one because she doesn't have a personality. She doesn't have the ability to have a conversation. She doesn't have the ability to be the one that lights up a room. So she wants to be the one that, has the information about this and that. And, she has the tea. But how did she get it? She got it by pushing people up against a wall. Because she has nothing. She doesn't have anything that, she's worked for, that she's worked hard for, that she's actually earned. She's just a little, I'm not going to go there. So I think that due to her nature, they knew that whatever came out in discovery, she would run and post about it. And I don't know how she thinks. I try to get into her head and I don't, because I don't understand, because most people involved in something like this would be smart enough to keep their mouth shut until all litigation is over. But she doesn't, and she just runs her mouth, and she creates this whole story that the court is on her side and that everybody's on her side and other people are getting in trouble and all this stuff, and nothing could be further from the truth. It says she's created a huge mess by the reckless nature of her reporting, and I think that this time she's going to have to pay out. This could cost her everything she has, and she's still not taking it seriously. So, the protective order is to protect 7M because of her reckless nature. I think that in the beginning, many of us thought the protective order would be for her because she didn't want people to know her financials and whatnot. And so I could see it that way. I could have seen it both ways. But from what I have here, this is where it is here. Okay. So this was filed in the District Court, State of Minnesota, on February 7th, 2023, and it's State of Minnesota, County of Wright, and this is the protective order itself. So it says here, 7M Films Incorporated with Robert Shin, Miranda Derrick, James Derrick as the plaintiffs versus Catherine Mansky Paulson, aka Katie Joy Without a Crystal Ball, LLC, as the defendants. Then it says the court hereby adopts and enters this protective order as follows. And it says any party to this action may designate documents and information as confidential information to protect it within the scope of Minnesota or Civil Practice P 26.03. So it number 2 says it's highly confidential, attorney's eyes only. Hereinafter, highly confidential means and is limited to confidential information that constitutes information that the producing party deems especially sensitive and is limited to private financial information, sensitive and private business information, medical records, and personal contact information. Access to highly confidential, attorney's eyes only material shall be limited to counsel of record only and cannot be distributed to clients, the parties, or other individuals. Okay, so that's where Katie Joy's attorney can see this. Katie Joy herself cannot. Okay? And that is probably really pissing her off. It says all confidential and highly confidential information shall be used solely for the purpose of this action, and no person receiving such information shall directly or indirectly use, transfer, disclose, or communicate in any way the information to any person other than those specified in paragraph 4. Any other use is prohibited. Number 4, access to confidential information shall be limited to the court and its staff, attorneys for the parties, their law firms, and their outside vendors who agree to be bound by the terms of this protective order. Persons shown on the face of the document have authored or received it. Or D, court reporters retained to transcribe testimony. Okay. And now it says the parties. And this is problematic because it says that they can't see it. And then right here it says access to confidential information shall be limited to. Okay. We go A, B, C, D, and then we turn it over and we go E, the parties. Well, didn't it just say that the parties can't see it, that only the attorneys can? So basically, I think that this is saying that if there's information in there that is under protection and she goes and posts it, it's going to be a huge problem. Okay? Because then it says that that outside independent persons, i.e. persons not currently or formerly employed by, consulted with, or otherwise associated with any party who are retained by a party or its attorneys to provide assistance as mock jurors or focus group members or the like, or to furnish technical or expert services and or to give testimony in this action who agree to be bound by the terms of this protective order. Now, this is kind of cool because long ago and far away, I did do it was a mock trial. And it was really cool. You made $300 a day. It was just a one-day thing. So $300, they catered in breakfast and lunch. It was so nice. But we were given all of the documents that they were the attorneys were going to use. They had a trial coming up and they wanted to see the possible outcomes. They wanted to see what jurors would see or be concerned with. So I understand when it's saying this about a focus group or stuff like that, because that actually happens. And then it says, all or a portion of documents and information disclosed in a deposition by a witness may be designated as confidential information and thereby obtain the protections accorded with confidential information. Confidentiality designations for depositions shall be made either on the record or by written notice to the other party within 10 days of receipt of the transcript. Unless otherwise agreed, deposition transcripts shall be treated as confidential information until the 10-day period following receipt of the transcript expires. The deposition transcript of any witness or any portion of such transcript that encompasses confidential information shall be taken only in the presence of such persons who are qualified to have access to such documents and information. Okay, now this is going to be important in a second because it says any party who inadvertently fails to identify documents and information as confidential or highly confidential information shall, promptly upon discovery of its oversight, provide written notice of the error and substitute appropriately designated documents and information. Any party receiving such improperly designated documents and information shall retrieve such documents and information from persons not entitled to receive them. Upon receipt of the substitute documents, shall return or destroy the improperly designated documents. The disclosure of documents and information that is later designated as confidential or highly confidential information under this paragraph to persons not having the authority under this protective order to receive them shall not, however, constitute a violation of this protective order if such documents and information are retrieved pursuant to this paragraph. Why? 7. Any party may request a change in the designation of any information designated confidential or highly confidential information. Any such information shall be treated as originally designated until the change is completed. If the requested change in designation is not agreed to, the party seeking the change in the designation shall, within 30 days of the requested change, move the court for appropriate relief. The party asserting that material is confidential or highly confidential information shall have the burden of proving that the information in question is within the scope of protection afforded by Minnesota Rules of Civil Practice 2603. Within 60 days of the termination of this action, including any appeal or by way of a settlement, each party shall either destroy or return to the opposing party all documents containing information designated Y, the opposing party, as confidential or highly confidential information, and all copies of such documents, and shall destroy all extracts, notes, compilations, and or data files containing such information. Each party shall provide a certification as to such return or destruction within the 60-day period. However, attorneys shall be entitled to retain a set of all documents filed with the court and all correspondence generated in connection with the action. Okay, so that's our part of that. Now we're going to Section 9 of this protective order. It says in here that any party may apply to the court for a modification of the protective order, and nothing in this protective order shall be construed to prevent a party from seeking such further provisions, enhancing or limiting confidentiality as may be appropriate. Additionally, no designation of confidentiality shall mean that the party making the designation is entitled to any presumption or determination that the information is protected under Minnesota state law or by contract solely because of the confidentiality designation, except as provided by this protective order. Number 10 states that no action taken in accordance with the protective order shall be construed as a waiver. Look at this error right here. Waive 3R. WAIV 3R. Look at that. These are court documents. And this is by the judge. Of any claim or defense in the action of any position as to discoverability or admissibility of evidence. Nothing in this protective order shall apply to documents and information which may be designated as confidential or highly confidential information if the information is publicly available or lawfully obtained by a party from a person who lawfully possesses the information. The obligations imposed by this protective order shall survive the termination of this action. Okay, now this one is not dated. I'm assuming that she has somebody write these things, but gosh, look at that. Shouldn't that have even came up in spell check? You have a waive 3R. Ugh, the errors we see here. I mean, is the world just devolving on its axis? Are people just getting dumber? I mean, these are court documents. Of anything that you would see that would be professional without error, you would think it would be this, but no. No. So now the reason why I want to show you that this exists is because depositions and interrogatories have already been completed. The reason why I know this is because there are errors in the discovery and interrogatories. So, although we don't see them, we know that they are there because they are referred to in further documents that I've found. And we know why we don't see them now, because of the protective order. So basically everything that was filed on that July 18th must have been answers to and whatnot. So all of this has already been done. Now let's think about this, because 7M and Robert Shin are putting forth an action against Katie Joy, asking the court for $1 million minimum. And that is on the actions that they have already talked about that have been subjected to interrogatories and discovery. She's continuing to post. What is she thinking? This should be something that had stopped, and they were looking at the damage in that, not as a continuing problem. I have never seen anything like it. I am absolutely shocked. There are other creators right now that are under Betty bit off more than she could chew, and she tried to sue Queen Bee, and she was going to go pro se because she was a paralegal for a federal judge, but no one can verify that. And in her class of 12, she was number 11 or something. I don't know. She thinks that she's so wonderful, but if you see her writing skills, it's just, maybe she's the one writing some of these briefs, I'm telling you. But anyway, she said that basically she wanted to sue Queen Bee because Queen Bee laughed at her. And so the community rallied around Queen Bee and helped her afford and retain an attorney. This attorney, very much like Amber, looked and saw, okay, we have a problem on our hands, and it's not you, Queen Bee, it's Betty. And so let's not only answer this, let's do a counterclaim. So he put a counterclaim against Betty. Well, Betty put a restraining order basically on the thing and said that she didn't want to she didn't want to be contacted by the attorney until she's in front of a judge. Which, as you can see, the process of litigation involves the attorneys talking things out back and forth. You don't just command that you have time in front of the judge, but Betty did. And I don't know if Betty has ultimately answered or not, but if she doesn't answer, then she's going to get a judgment from Queen Bee's counterclaim. And it's funny because I think that she bit off more than she could chew. And the thing is that from Queen Bee, when people ask her about it on her panel or in conversation and stuff, she can't talk about it. It's just like, you know what, right now that's in litigation. It's nothing that we can discuss, change the subject. That basically whatever was done at what point is there. It's not like then she goes and does a stream about Betty that day or brings up Betty or anything like that. It's that right now they're under litigation. They're not talking about it. And that's that. So for Katie to keep pushing this, I just don't see how it's stopping, because if they've already done interrogatories and discovery based on her earlier postings in 2021. What are we doing now in 2023 with the information that she's putting out there? Are they going to have to keep amending the complaint? Are they going to have to file a whole new cause of action? I don't know. I've never seen anything like it. Like I say, now this is what I attended. So this was the way that the proposed order was set up. Okay. And this is where this specifically talks about what I just said here. Because this proposed order, so this was written, so I obviously had this, so when the orders are put in, so then the judge has the order there and they just sign off on it. So this one was not finished because I got a copy of it before this date happened. Because it says here, the above entitled matter came before the undersigned Honorable Judge of the District Court on August 1, 2023 at the Wright County Courthouse. Amber J. Stavig appeared on behalf of the plaintiffs. Jennifer Moore appeared on behalf of the defendants. Based upon all of the files, records, arguments of counsel, and the parties and proceedings herein, the court makes the following. Okay? And this is where this was the proposed order. This is before anything happened. And I had obtained that day. So it says here, the findings of fact, conclusion of law, and order for judgment. And it says look at this. What is this? Another error. On May 11th, 2023. Look at that. Who did this? And this is supposed to be from the judge. So whoever the judge has writing her papers needs to go back to, maybe the judge needs to hire Betty. Because on May, that is terrible. On May 11th, 2023, defendants were served with plaintiff's first set of interrogatories, request for production of documents, and request for admissions. Okay. So right here, that's showing that Katie Joy was served with the plaintiff's first set of interrogatories. Do you remember that Katie Joy just said that the other side isn't answering, they're not doing anything, and she's doing everything right, and the other side is in trouble because they're not doing anything? That's bullshit. Absolute bullshit. It's her side that's, anyway, and then it says here on June 12, 2023, defendants served their answers to plaintiff's first set of interrogatories, request for production of documents, and request for admissions upon counsel for plaintiffs. Okay. So that means that Katie Joy served their answers to 7M. On July 7, 2023, plaintiffs served defendants with a letter outlining their discovery deficiencies. Okay? So, the plaintiffs then served Katie Joy with a letter outlining their discovery deficiencies. Remember, she's saying that the other side isn't doing it. This says differently. Okay? Now, it says, pursuant to the Minnesota Rules of Civil Procedure 33, 34, and 36, defendants are required to participate in discovery relevant to the lawsuit at hand. Okay? Katie Joy is the defendant. This is saying in here that she is the one not participating. Now we go to number 5, and it says defendants have failed to respond to relevant discovery and disclose information relevant to this lawsuit. Again, the defendant is Katie Joy. This is outlining that Katie Joy's side has not done what they are supposed to do. Okay? Number 6 says the court finds defendants have failed to respond properly to plaintiff's discovery pursuant to Minnesota Rules of Civil Procedure 33, 34, and 36. Okay, so again, the defendants have failed. That's Katie Joy failing. They failed. Now it says here, plaintiff's motion to compel discovery is hereby granted. That means that Katie Joy lost here. And now it says, pursuant to Minnesota Rules of Civil Procedure, page 37.01D, cost, disbursements, and attorney's fees associated with the plaintiff's reasonable expenses incurred in making their motion to compel be granted. And number 9 says, plaintiffs shall submit and affidavit. Look at that. It should be an affidavit instead of and affidavit of its costs to the court within 14 days for its costs. That doesn't even make sense. Plaintiff shall submit and affidavit of its costs to the court within 14 days of its costs. Okay, that's just a messed up thing. And it says, let judgment be entered accordingly by the court, dated by. Okay, so the judge could have just whomped. The judge could have said, you know what? I see this. The other side has failed. What do you say? And she says, I don't know. I was on vacation. What was I supposed to do? I don't know. And the judge would have been like, okay, that's not what you do. You've been an attorney for how many years? You know better than that. You plan better than that. You don't take a vacation when you have interrogatories that are due. This was not overnight. This is something that was put in order how many months ago? And so then because of this dereliction of duty, I go ahead and I grant the relief to the plaintiff that is requested, and a judgment is imposed at this time for this amount. That's what the judge could have done. But as we know, the judge didn't, and I explained exactly what happened. But this is the way it could have went down in this proposed order. And again, it is showing that Katie Joy's side is the one that is not doing the right thing. And as stated here, we can see based on what they're referring to that the interrogatories all have been done. Now, another thing here is that I've done this several times while I was looking at this just to make sure that I had everything right and that everything is done. Look at all of this here. All of these and all of these page counts and everything are all because of Katie Joy and her actions. So this is everything that's happened in the case to that date, okay? So everything from 4/5/22 to 7/25/23 there. And you can see here that we've got everything, all of the memos, everything, affidavit for plaintiff, answer, affidavit of attorney, affidavit of defendant, correspondence. There's every single thing here. And I have all of the emails, and I have everything to show that Katie Joy was just lying. As usual, this register of actions breaks it down better. And I went ahead and blocked out and redacted her address as well as Robert Shin's. So on this is page 1. And on here it has correspondence. And it goes back and forth. And I went through and I checked it to see and make sure that, what Katie Joy is saying is false. It is. I mean, this is page 1. This is page 2. So we go back and we see, okay, that's served. So all of these emails I went back and forth to make sure that one side was answering the other side. One side was answering the other side. Here's page 3. Here's page 4. I made sure that everything is there. Everything is there. Each side is answering the other side as the motions come in. Page 6, page 5, page 6, okay? Go in here, look at all of these emails. All of these emails. Okay? They're all there. And it's not like Katie Joy is saying. And here we are to page 7 and 8. She gets a copy of it each time. You can see that, both sides are answering back and forth, back and forth. Okay. And then we're all the way to page 9 and 10. So every single email got 10 pages of emails back and forth. Back and forth. 11 and 12. Okay. I checked it all. I went back and forth, back and forth, back and forth, making sure that what she's saying is not true at all. Page 13 and 14. So, got that. Then I've got page 15 and 16. Same thing. Just documenting all of the emails. Got 17. I've got 17 and 18. Checked them all. Got 19 and 20. I've got 21. And 22. And 23 and 24. And you can see, when it goes through, and then the other side answers. The other side gets served back and forth. It goes back and forth. They're just playing tennis, basically. And we got 25 and 26. I got 27 and 28. And I've got page 29 right there. So there's 29 pages that I checked through to make sure that what Katie Joy was saying is not true, that the other side is not answering their emails, that she's doing everything right and they're just not answering, and it's not true. I have everything here to prove differently. And I have all 29 pages of the emails that I went through back and forth to show that they're there. And I was even thinking, what I should do is highlight each side, with a different color, or find a way to put in like 2 different jars and say, okay, this is an email for her side, this is an email for their side, hers, theirs, to show that, look, here's all these pages, but to be sure that that is all going down. But doesn't she realize that her lies can be proven wrong? I just don't understand why she's so reckless. Now, in this one, this is just another thing that I wanted to just show you, just, so you understand what I'm saying. This is where the notice of motion and motion to compel discover responses. Okay. Now this goes to show that, one more time, that she is the one who's not doing the right thing, because this notice of motion and motion to compel discovery was to her. It says to defendants, blah, 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 blah. And it says that at 9 a.m. on Tuesday, August 1, 2023, at the Wright County District Courthouse, blah, blah, blah. Plaintiffs 7M Incorporated, Robert Shin, Miranda Derrick, and James Derrick, plaintiffs will bring on for hearing before the Honorable Judge Carrie Willis, Judge of District Court, their motion to compel discovery responses from defendants. So this is backing up what was supposed to have happened on August 1. Again, reiterating that it is Katie Joy's side that is not complying. That what Katie Joy says is the opposite of the truth. Okay? This is I don't know why she is so confident to lie like that. And then this is just a duplicate of the one that I already read through. Now, this is a replying memo, and I'll go through that in the next couple of days because then it does get into more of that. But I just wanted to take a little bit of time to hopefully set some things straight, so that I can get back to reading line by line to get where we need to be, so that the chatter about Katie Joy winning, somehow people being in trouble for listening in on the Zoom, or that the other side is not doing what they're supposed to, or that she is in any way winning. I hope that all of that is put to rest, and I hope that you can see that there is a protective order. Discovery and interrogatories have went through. The protective order is as stated, and it's her side that's dragging. It's her side that's problematic. She couldn't get competent counsel, and it's showing. I would be very, very bottom line, Katie Joy is paying that attorney per hour. And if that's what she wants to do, I don't know at what point she's going to go back and say and look at her actions and see if she doesn't need to quit her channel, basically, and just go back to being maybe very present with her son and her husband, and look at her life instead of living a life of just talking about people that she's obviously very, very jealous of. This just smacks of jealousy and an inner rage that she has against other women who are good moms and who do the best they can and who interact and are present with their children. She's very, very nosy into other women's business, and I think that there are some deeper issues that she needs help with, and hopefully one of these days Katie Joy will get the help that she needs to understand that instead of looking out, she needs to start looking in and stop causing this kind of havoc in people's lives. Until then, I will be here to expose her lies as lies, one by one, line by line. I'm here to do it. I'm here to stay. So thank you so much for listening. I absolutely love all of you and love all of the support you give me. I'm so thankful. And if you'd like to buy me coffee, please. My Cash App is Tabitha Jane 13. My little boo is on my my little Cash App thing. So Tabitha Jane 13. And I will talk to you guys again soon. Thanks for listening. Bye-bye.